13 new proposed guidelines for mergers. Federal Trade Commission Chair Lina Khan speaking to the Economic Club of New York not long ago after losing two key antitrust cases. Here's what she had to say about how the losses affect the FTC's strategy moving forward.
We in federal court have lost two merger cases. We have brought somewhere between 13 and 20, depending on how you count, and have gotten abandonment. So in the scheme of our merger enforcement program, losing two is okay. Obviously, we only bring cases that we think we should win, that we can win. Every time we have that type of setback, we look very closely at where could we have done better, where did we fall short, and use that to inform our approach going forward.
Joining us now to discuss is Bill Baer, former Assistant Attorney General for the Antitrust Division at the Department of Justice and a visiting fellow at Brookings. He's the only person to have led enforcement at both antitrust agencies of the FTC and the DOJ. Bill, welcome. How are you? Good to see you.
Thank you. Great to be here.
What is your response when you hear Lina say, "Hey, we've won more than we've lost," but the two losses were pretty significant ones involving big companies that everybody knows?
Yeah, I think she's right that you don't bring cases that you think you're going to lose. You think you've got a factual basis for it, but many of the other challenges they brought have resulted in companies saying, we give up, we're not sure we can win in court. And so those numbers are relevant to an overall assessment of how well she's doing at the FTC and her counterpart, Jonathan Kanter, is doing at DOJ.
As you step back and you look at Ms. Khan and Mr. Kanter's approach to antitrust, something you know better than maybe anybody in the country, what would you say is being articulated about their approach? Is it different from the way it was? Are they going after qualitatively different kinds of combinations or concerns, or what? How would you? What is the Biden administration, the regulatory philosophy that is holding true today?
That's a great question. I think, to try and put it simply, they are saying that over the last 40 years, antitrust enforcement has gotten too conservative. And what's happened as a result? We have more industries that are more concentrated, less competitive, and that does not serve consumers. It doesn't serve competition. It doesn't serve workers well. So they are going back to basics. These new draft guidelines say, if two companies are merging, let's look at how they interact today and what's going to be lost in terms of competition if this merger goes forward. So it is a more realistic, less dogmatic, less theoretical, and more practical approach to making sure consumers, workers, and the overall American economy benefits from competition.
So if you're reimagining or revisiting or expanding the definition of antitrust, how much of that is actually the jurisdiction of the FTC and the DOJ versus Congress basically coming with new legislation?
Sorry to interrupt you there. It's what the antitrust enforcers under Biden are saying is we need to go back to what the statutes actually say when it comes to mergers and acquisitions. Is there a tendency, a risk that a combination, a Live Nation Ticketmaster will end up harming consumers and competition? That's what the Clayton Act, which is the merger statute, says. It's taking a look at risks that things will get worse. And it involves a prediction. And the Chicago School of Economics has basically taught us that, let's just tighten the standard, require the government to prove a certainty rather than a risk or a tendency. So I don't think we need new law. We just need more fair application of the law that Congress wrote.
So what is your takeaway then of what we've seen play out in the U.S. court system? Because I realize there's still a European and UK specifically regulatory situation going on, but specifically in the U.S. court system around Microsoft and Activision.
Well, first of all, the FTC was unable to prevent the acquisition from taking place. But in the course of the U.S. investigation, the European investigation, and the UK investigation, Microsoft effectively conceded that without commitments, it had both the incentive and the ability to favor itself and its gaming system over its competitors. So Microsoft was forced to make ironclad commitments to make games like Call of Duty available to its competitors. So while the government did not successfully block the thing in its entirety, it extracted concessions, which potentially, hopefully, will allow Activision games to continue to be widely available.